behalf of Bangalore Chamber of Industry and Commerce, we welcome you all for this special talk on personal insolvency and bankruptcy, addressed by Dr. K.S. Ravichandran, Managing Partner, KSR & Co., Company Secretaries LLP. Thank you very much, sir, for accepting our invitation to address at this session. The aegis of Banking, Finance and Corporate Affairs Expert Committee of the Chamber. Now I will request Dr. Om Prakash to take it over from here. The Chamber also acknowledges the support of our member organizations who have sponsored the annual events, Messrs. Bueller, Fundromax, Wipro, MTR Foods, and Sona Group of Companies. Over to you, Dr. Om Prakash, sir.
Thank you, Rupa, and welcome all to this yet another webinar. And this time we are having a topic, a very interesting topic, personal insolvency and bankruptcy. People have heard about corporate insolvency, what NCLT does, but this is something which is very unique, and thanks KSR for prompting this topic and quickly getting into the mode of batting even before the bowlers were ready. Thank you very much, and I think this topic was very interesting. Everybody liked it. Instantly it got agreed. Before giving the floor to him, I would introduce him. My privilege actually to introduce such a very senior personality who has been a veteran in the corporate laws. We normally call him Dr. KSR, very nickname. It's like KS Ravichandran. He's very young at 58 and has masters in commerce, law, then fellow member of ICSI, a lawyer by qualification, post-graduation. So he is practicing since 1994. That is those days when SEBI and the public issues were at helm of affairs. So he is a very old senior member, and he has an expertise in corporate laws, security laws, foreign exchange, and he also is good in IPR, ADR laws. You name it, his hands are there. He is soiled everywhere, and he represents NCLT, NCLAT, CCI, IP, AB, High Courts, Supreme Court as well. So his presence of practice is felt everywhere, and his knowledge takes him to be an expert advisor on various committees. He holds a doctorate from Alagappa University on prosecution of corporate directors in India. His darling topic is directors. So that too on prosecution. See the doctorate he has done on. And holds an UK degree as well. Interestingly, he holds a diploma in electronics and radio communication engineering by IIF, and he is an Air Force man. I saw in his profile, before plunging into corporate laws, he had served the Indian Air Force for over 9 years as a specialist in Russian radars before switching over to the profession of company secretaries. For a brief period, he was a lecturer in commerce for the government of Arunachal Pradesh at Pasighat. Sir, diversity. I didn't know he was part of Air Force, and he has written books like second edition of books on related party transaction by LexisNexis, and fourth edition of his book is on a guidance to compounding adjudication and prosecution. Then corporate social responsibility by LexisNexis. In addition, he has authored several books such as Law Relating to Limited Liability Partnership, the Law Relating to Debt Recovery and Winding Up, and Secretarial Securities and Management Audit. He has spoken in more than 500 conferences and webinars and has authored thousands of articles. Here we go with Dr. KSR to talk about and share his experience on personal insolvency and bankruptcy. Members are requested to attend, and QA sessions will be followed. On to you, Mr. Dr. K.S. Ravichandran. Thank you.
Thank you, BCIC, and a special thanks to my friend, learned advocate Sri Om Prakash. There cannot be bankruptcy of ideas. Because after this law was introduced, I had a very personal experience at IBBA as one of the invitees to at least 2 occasions to explain the structure of this code and the provisions. And also once I was fortunate to be amongst the POs and registrars of debt recovery tribunals across the country for the purpose of creating the awareness about the code and the structure. Prior to 2019, I'm saying. Hope I'm completely audible. Now, that time when we were talking about the corporate insolvency resolution process, several things were not clear, several things were not settled in relation to corporate insolvency resolution process itself. And even today, questions are being answered, and finality is achieved by the intervention of Supreme Court. I can say timely intervention of Supreme Court in several matters, even in CAR. So 2019, the government thought it fit that it shall introduce a special class of people called Class 2E people. This Class 2E is nothing but the glossy people. I always call them glossy because they are the directors and promoters of the corporate, and they are the personal guarantors to the corporate debtors. So therefore, Class 2E is, I always term it as a glossy class. Because during the BAFR days, we used to see the promoters coming in Mercedes-Benz car and climbing up the 23 stairs in NCA, this BAFR in Connaught Place, and looking at resolution of sick industrial companies those days. The law has not changed. Fundamentals have not changed. Fundamentally, the guarantor's liability is coextensive. Fundamentally, the guarantor can be proceeded against, and the creditor has the right to proceed against the guarantor individually, separately, without taking action against the principal borrower. Therefore, the law fundamentally has not changed, it is evolving. Once the corporate insolvency resolution process is on, the idea of the code, as I understood and as I see today, is to see that what are the revenue streams that can come to the committee of creditors who represent the body of stakeholders who will get if there are anything. One is, of course, through the resolution plan. Another is, of course, through the various avoidance transactions and surcharge proceedings that are taken against the directors or promoters or persons who have dealt with the company. And the third stream of revenue could be the guarantors. In MSME sector, I can tell you clearly that there are very, very few cases, hardly very few cases where the banks have been able to recover money from guarantors unless there is a property of the guarantor which has been mortgaged and that is brought under the SARFAESI Act. For example, if a person like a bank would want to invoke the proceedings of the against the personal guarantors under 95 of the code, they would think twice if they had the security of the personal property of the guarantor. Because you will not be able to put yourself into difficulty by invoking the personal insolvency resolution bankruptcy proceedings and creating a moratorium, taking action against your own action, whatever you can do. Therefore, if there is a property of the individual guarantor which is mortgaged, the bank will think twice before invoking the code. against the personal guarantors also, because they can always go under the SARFAESI. The CARP moratorium does not prevent the action against the individual properties or the outside the balance sheet of the corporate debtor. That is the kind of scenario we are having it. Therefore, today, the borrowers have to face the corporate insolvency resolution process. The driver's seat is gone to the resolution professional with the confirmation of COC for various things. The directors and promoters who were in the driver's seat has been suspended today. They have become passengers. In MSME, they can also join in creating and giving a competing resolution plan, and that's all. In addition to that, the financial creditors can also initiate action against the personal guarantors under the code, which will kickstart the process of insolvency resolution, bankruptcy of the individuals. And the only natural persons who are permitted today to bring under this scheme of things under the code is the corporate guarantors, personal guarantor, corporate debtors, personal guarantors. That is called PG to CD. And the code does not stop with that. The code also provides for a bankruptcy. Therefore, we are going to discuss two parts. Once a program is initiated, when an action is initiated, a proceeding is initiated against the personal guarantor to the corporate debtor, there are two parts. One is the insolvency resolution, which can result in repayment plan. As a result of repayment plan, 119 discharge can take place, or repayment plan fails, or there is no repayment plan at all, there is no possibility of repayment plan, the creditor can initiate a bankruptcy separately, another part of it, which is like a waterfall. And in bankruptcy also, 138, there can be a discharge. Therefore, when we talk about personal guarantors to corporate debtors, we have to see two things. Number one, the guarantor is the debtor, the individual guarantor, who can initiate this code and this process of insolvency resolution of himself, herself. This is called apnea of proceedings. Creditor can also initiate it against the guarantor, debtor. Both can go in the same track and result in repayment plan getting sanctioned, or repayment plan failing, discharge order not possible. Therefore, right to invoke bankruptcy starts, and therefore the second part kickstarts, and bankruptcy can result in declaring the person as a bankrupt, and post declaration as a bankrupt, a discharge. Therefore, the scheme of things is as follows: that the guarantor debtor can look at the scenario and take action on his own and bring a Section 94 action, which means he himself invites the proceedings against him or her. Now the next is creditor. The creditor can also initiate parallelly along with CARP, or at the time of liquidation or thereafter, and initiate proceedings for personal insolvency of the personal guarantor to the corporate debtor. The entire first part works on this basis, that an application is made by the guarantor debtor or the financial creditor, whoever is the creditor whose debt is in default, and immediately an order is passed by the adjudicating authority asking the RP to furnish a report. And in 99 and 100, these are all numbers, we do not really bother about it. A report comes, result of the report is a repayment plan can be there, and as a result of the repayment plan could be that it is implemented, it is completed, and therefore resulting in the individual getting a discharge. So there are only two scenarios. Who commences, whether the debtor guarantor starts or the creditor starts, is not the issue. The process is very simple, that there could be an order of the adjudicating authority asking the resolution professional to sit with the debtor and the creditors, prepare the repayment plan, see whether repayment plan is possible, see whether the repayment plan is approved, see whether the repayment plan is implemented, see whether the repayment plan is completed, and thereafter discharge. This is the brighter side of the whole provision. Or in the other case, it is not possible at all. there is no resolution possible, the RP can report to the adjudicating authority. RP may also report repayment plan is possible, it was approved, it did not work, it did not get completed, it was not implemented, it is not possible. Therefore, there could be a provision which under this first part triggers the second part where the creditor can apply for the bankruptcy. It is the bankruptcy which everybody is concerned, because once you start declaring somebody as an insolvent or a bankrupt, people have the fear. That is why in India, in spite of the provisions of personal guarantors to corporate debt are coming into force, in 2019 itself, we do not see very many applications, whether by the creditors or by the guarantor debtor across the country. Still, they have not probably grappled with the idea of this, because even today, insolvency or bankruptcy is considered as a taboo. But under the code, it is not necessary to be so. Under the code, if you are declared as a bankrupt, you run the risk of suffering certain disqualifications and restrictions, and thereafter you apply for a discharge, and once the 138 discharge order is passed, you are a fresh person. All your assets, everything goes into the custody of the bankruptcy trustee only. He takes his own time, whoever is the bankruptcy trustee. You are not required to worry. 1 year of bankruptcy is over. File an application for discharge, come out of the bankruptcy, do your job. So this is the whole background of this resolution process and bankruptcy with respect to personal guarantors. Now, for the next 10 minutes, I will show you a presentation also, giving this preface as an introduction. This 94 to 120 is that insolvency resolution of the personal guarantors. Lalit Kumar Jain Supreme Court held that resolution plan does not ipso facto discharge a personal guarantor of her or his liabilities under the contract of guarantee. This is general law. Resolution plan cannot discharge the guarantors who owe a liability separately. Of course, they will not be called upon if resolution plan brings good amount of return. And we know that that is only a wishful thinking. It is like the mirage on the desert, because resolution plans definitely result in, very importantly, and we can say definitely, haircut. Therefore, the question of resolution plan bringing good amount of money and thereby guarantors are not going to be really fired is a very wishful thinking. However, the fundamentals of law is simple, that the resolution plan is approved under the section 31 of the code by the adjudicating authority does not result in discharge of the personal guarantor, because the personal guarantors can be discharged only by the person to whom the obligation has been undertaken by the guarantor, that is the financial creditor. This is what Lalit Kumar Jain said. Of course, I will come back to Lalit Kumar Jain on another note, which I will tell in a short while. Ramakrishnan was a judgment prior to Lalit Kumar Jain, and Lalit Kumar Jain was brought because that was a time when the notification was there in 2021. You can see the notification was in 2019 February and November, 15th November 2019, and Lalit Kumar Jain was 2021. Prior to that, 2018 itself, Ramakrishnan, the question was answered that the period of moratorium is not applicable to personal guarantors, which means the personal guarantors provision under the code was not in force, but banks are entitled to initiate proceedings before DRT or SARFAESI. And at that time, Supreme Court said the moratorium that affects the corporate debtor does not apply to the personal guarantors. This is what we normally say as moratorium concerns with the balance sheet of the person in whom the moratorium operates. And in the case of corporate debtor, the balance sheet assets of the corporate debtor alone will be subject to the moratorium, and therefore Ramakrishnan said it shall not apply to personal guarantors of corporate debtor. That is how the law evolved. You can see August 2018 this decision, 15th November 2019 the notification notifying this part of the code, bringing into force the insolvency resolution and bankruptcy of the personal guarantors to corporate debtors. And come 2021, you have the Lalit Kumar Jain endorsing the view that there is no way the resolution plan could be said to be discharging the guarantors. After all, it discharges only the corporate debtor, and that is the circumference, or we can say the perimeter of the resolution plan approval and the binding nature of resolution plan. The provisions are like this, that you have a 15th November 2019 notification followed by two sets of instruments. One is the regulations, another is the rules. One is the regulation which says how it should be done, what repayment plan or how it should be organized. Another is the rule with respect to what is the application to be made, in what form the 94 application by the guarantor debtor will be made, or in what form by the creditor's application under 95 will be made to kickstart the insolvency resolution process. What are the information to be provided? I am telling you 95 is a very simple form. Financial creditors can make a very easy application, but 94 is a nightmare. To work on 94 for an individual guarantor debtor is going to be a tough task, particularly if you're dealing with a person with huge debts and very many assets and several financial creditors and all. It's going to be very, very tough task. 94 is not an easy job. Then you have the entire scheme of things starting from 94 running up to the 120. This is the insolvency resolution process. I have already explained you the we can say the brief about the structure, and therefore we don't need to go into the each and every provisions. Now you will find two things in this code which are very useful. Now, number one, when the resolution process for the individual is started, whether there will be something that he can retain or she can retain, that is explained by excluded assets. Even in bankruptcy, these excluded assets will be personally available, and there are some dwelling units like 600 square feet, some insurance policies, some pension plans, some ornaments which are religiously very important that cannot be, for example, like a Mangal Sutra and all, unencumbered furniture, etc., books and vehicles, for example, a laptop or something. I think these are all the excluded assets which will not be touched by the proceedings. Therefore, at the end of the day, this is what the person can have until the person is discharged. 119 or 138, discharge ke baad, he can always bring anything. This is one important provision in this code. The next one is about excluded debt. For these debts, you cannot commence these proceedings. It should be a debt relating to some guarantee. Therefore, if you are suffering a fine, if you are having a award against you, paying the damages, or for example, there is a penalty of an adjudicating authority such as, let us say, SEBI levying some 5 crore penalty on an individual, he cannot escape the rigors of law by invoking the proceedings under this code. Therefore, excluded assets and excluded debt are two things which you must remember in this code. When it comes to applications, the personal insolvency application cannot be made if he is an undischarged insolvent undergoing a fresh start process, which for the time being we can leave it, undergoing the insolvency resolution process already, or undergoing the second part bankruptcy process. This is another important thing. We should know what are the things the individual can keep. We should know for what debt he cannot initiate this proceeding, and we should know who can and who cannot. Who cannot is given in this slide. Then interim moratorium is something when you file an application, the moratorium starts, that moratorium pertains only to legal proceedings with respect to debts, not for all proceedings. That is, number one is legal action, proceedings, and with respect to debt of the debtor, not for properties, not for anything else. This is the concept of interim moratorium, which starts immediately. There are procedures like 99 report, 100 order, repayment plan, all these things. And then a final proper moratorium on the 100 will be there when adjudicating authority passes an order on the repayment plan. And therefore, that is the time when we should know the personal guarantor's entire assets come under the moratorium. Repayment plan can be structured, it could be stretched, it could be whatever is assets. You always have a particular level of assets and a particular level of liabilities, and most of the cases the assets will not be sufficient for meeting the liabilities, and most of the cases the MSME, for example, if you take, they have borrowed 100 crore loans and facilities, etc. But the individual's assets may not be that much. It could be some 5 crores, 10 crores at the best, including his own big house and all. Therefore, what happens is generally the assets are insufficient to pay this thing. Therefore, even if CARP is going on, if resolution plan brings some money, let us say some 15% or 20% recovery comes, the rest of the money, 80%, is not going to be serviced so easily by the debtors' assets, and there could be several guarantors. Therefore, the committee of creditors will consider all these things. Ultimately, they may approve a repayment plan, which need not necessarily bringing all the money that is due to the creditors. Repayment plan need not be for a specified period saying, okay, I'll finish everything in 3 months, 1 month and all. It could be for a longer period. It could be even paying that out of my personal income from other sources. Every year I will pay some 20 lakhs, 30 lakhs, 1 crore, etc. So there could be anything can be written, provided it is approved, provided it is implemented, discharge will not take place. Bankruptcy starts when repayment plan fails or repayment plan is not possible, when even 100 the result is not possible. So therefore, adjudicating authority rejects the application for insolvency resolution in the threshold at 100 itself. Bankruptcy application can be filed. Repayment plan is rejected, bankruptcy can be filed. Repayment plan is not implemented, bankruptcy application filed. So bankruptcy is the important part of this code with respect to which we are going to now discuss. The bankruptcy contains these provisions, and ultimately what is the effect? That is what we are interested. The effect is the estate of the bankrupt goes to the bankruptcy trustee. What the bankruptcy trustee will do is a separate task. He will go into various transactions, fraudulent transactions, avoidant transactions. He will take charge of the assets. He will bring auction, action, whatever it is. Ultimately, he will distribute the dividends to all the stakeholders, and secured creditors can stay out also in bankruptcy. Disqualifications. A bankrupt is not entitled to be appointed as trustee. He cannot be a public servant. He cannot hold a public office, MLA, MP, something like that. He cannot be elected, sitting, voting as a member of local authority. These are all the disqualifications. Therefore, if you see 140 disqualifications, people will think these disqualifications are not great for an individual like me, and therefore I am not really worried about, because I'm not going to stand for election or become somebody here, and therefore this disqualification really does not matter for an ordinary you and me. Come to the restrictions. What are the great restrictions in this law? One, you cannot act as a director of a company. Fine. You are already, all your assets are there, your directorship is already suspended, and a resolution plan is approved. Your corporate debtor, you are going to be discharged, you are going to be removed from the position of directorships, and therefore directorship of existing company is gone. You cannot be a director of any other company. Fine. There is no great difficulty in that. Previous sanction of the bankruptcy is needed if you want to create a charge on any of your estates, because it is going to the custody of the bankruptcy trustee to raise money and close it. You should be able to inform your partners that you are undergoing a bankruptcy process. Everybody should know that you are a bankrupt and you have been declared as a bankrupt and you are undergoing a bankruptcy process. Prior to entering into financial or commercial transaction, you should be able to inform all the parties. Otherwise, you should not sign. The declaration that you are a bankrupt is what the law requires. And you are incompetent to maintain legal actions in relation to bankruptcy dates, and you are not permitted to travel overseas without the permission of the adjudicating authority. Therefore, this is that the entire difficulty for you is contained only in these restrictions and not much. I don't think there is any great difficulty that you are going to suffer in this bankruptcy order or in the disqualification or in the restrictions. Coming to the other part of it, you will find this is the latest judgment of the Supreme Court in Mahendra Kumar Jajodia versus State Bank of India. This was a matter where originally the appeal is, the NCLAT has allowed it. NCLAT has said, yes, whether CARP is there or not, whether liquidation is there or not of the corporate debtor, financial creditors proceedings can be initiated, can be proceeded against in relation to the personal guarantors. That was the decision of the NCLAT. As against that decision of the NCLAT, the Supreme Court originally granted a stay. The Lalit Kumar Jain was the subject matter of discussion there also. They reproduced the Lalit Kumar Jain's days in section 60 within brackets 2 prescribes in the event of an ongoing resolution process or liquidation process, an application for resolution process or bankruptcy of the PG to CD shall be filed with NCLT, and therefore the adjudicating authority for personal guarantors will be NCLT. This is section 60 they are referring to. If a parallel resolution process or liquidation process is pending, if a parallel resolution process or liquidation process is pending in respect of the corporate debtor for whom the guarantee is given, the same logic prevails under section 60 subsection 3, because insolvency bankruptcy proceeding can be there before a tribunal. Of course, this is not operationalized. Therefore, this will never come today until the DRTs are activated, and generally it is going to be created. Today, when any insolvency or bankruptcy proceeding is pending against the personal guarantor in some other court or tribunal, the resolution process for liquidation can be initiated. Thus, Supreme Court says in Lalit Kumar Jain, an individual is the subject of a resolution process before DRT. He has furnished a personal guarantee for a debt owed by the company B. In the event of resolution process initiated against B in an NCLT, the provision results in transferring the proceedings going on against A in the DRT to NCLT. Therefore, Lalit Kumar Jain, Supreme Court explained subsection 2 and subsection 3 of section 60 because personal guarantors to corporate debtor insolvency resolution was brought under the jurisdiction of the adjudicating authority, that is NCLT. And that time, as we understand from Lalit Kumar Jain, was that only when CARP is going on or when liquidation is going on, the personal guarantors insolvency resolution under 94 or 95 can be initiated. That was the opinion, and that was what Supreme Court itself read from the following paragraph. And thereafter, in Jajodia case, there shall be a stay of the operation of the NCLAT order. This was what Supreme Court said in Jajodia case in this order on the 21st March 2022. Now, the Supreme Court finally disposed of in 6th May. You can see here this is just 21st March, and here you can see here this is 6th May. Less than 2 months the matter is resolved, and the Supreme Court has passed the following judgment that we do not see any cogent reason to entertain the appeals. Therefore, the NCLAT order stays. What does the NCLAT say? NCLAT said whether CARP is there or liquidation is there or not with respect to the CD, action against the PG, that is personal guarantor, is possible. Now, you can see here this is another case where the appeal is withdrawn with respect to the CARP. That means CARP is not there. And in this situation, you can see two things I am going to show you. Carefully, you can watch the date. See this. This is a Jajodia case which we have discussed just now. This is NCLAT. This is first bench. You see here. January 2022. The NCLAT first bench Ashok Bhusan that the adjudicating authority has heard in holding that since no CARP or liquidation proceeding of the CD is pending, you can commence action under 95. This is what Supreme Court finally held, and therefore NCLAT's decision on this day, that is 27 January 2022, is continuing. I mean, that is upheld by the Supreme Court. Of course, Supreme Court said we do not find any cogent reasons to interfere with, but Supreme Court did not give any cogent reasons to say what is the interpretation and why they have changed the view and how they have upheld the NCLAT's decision is something which we need to consider separately. That is a legal matter. Ultimately, on 27th January, when NCLAT had passed this judgment on 27th January, allowing the CARP to allowing the personal guarantor's action to continue despite there being no CARP. On the very same day, in Chennai bench of NCLAT, arguing on Lalit Kumar Jain, we took a stay of action against the personal guarantor. So today we have on 27 January itself two decisions of NCLAT. One is an interim stay granted against action against the personal guarantor on the ground that there is no CARP. And on the same day, NCLAT saying you can commence the action against personal guarantor even if CARP is not there. Therefore, ultimately, currently, for the purpose of our consumption, without worrying about all these legal interpretations and all, Supreme Court has very clearly now said that personal guarantors can be fired, attacked under 95 by financial creditors, irrespective of whether the corporate debtor is undergoing CARP or liquidation or after that or before that. Therefore, the position is very clear. Fundamentals of law has been restored that the liability of guarantor is coextensive. Borrower is, let us say, a corporate. The corporate debtor may be under CARP, may be under liquidation. Irrespective of that, personal guarantors can be attacked, and personal guarantors against personal guarantors, action can be initiated. Financial creditors have the SARFAESI Act in front of them for properties which are securing their debts and liabilities, and they also have the provisions of the code to initiate under 95 and result in discharge probably for the bankrupt under 138. Therefore, this is what I thought I'll share with you. Thank you. So I am done, sir.
Thank you, sir. Thank you very much. A very exhaustive approach with all the Supreme Court judgments and the provisions from 94 to 120 of the NCLT. A really wonderful insight you have brought across with the judgments were from 2018 to as late as January 2022. Fantastic, sir. And the way the personal guarantor looks like is even before starting an CIRP against the corporate debtor, I think you can proceed against the guarantor itself if there is a huge, if we believe that that particular assets are going to suffice without touching the corporate debtor. Is this something we can really think of?
Correct.
It is. It looks like, it looks like. So if the personal guarantor really have that kind of an asset, I think the corporate debtor need not be troubled, and directly the personal guarantor can be brought into the process, and a solution can be amicably solved. And if he has a large asset base, and as regards the impact and effect, that is wonderful. So you mentioned that the uh, guarantor, after undergoing this process, can come out as a fresh person after a period of 1 year. So is there any law in that, sir? Any period?
Yeah, that is the discharge order is passed under this law. Once you are, let us say, declared as a bankrupt, you can see that the bankruptcy trustee under section 138 shall apply to the adjudicating authority for a discharge order on expiry of 1 year from the bankruptcy commencement date or within 7 days of the approval of the committee of creditors of the completion of administration of estate where such approval is obtained. So what happens is, even though a person could have been declared as a bankrupt, within 1 year from the bankruptcy commencement date, it is possible to apply for discharge, bankruptcy trustee continuing with the assets which are under his custody, which means the individual can get discharged within 1 year, and thereafter he may not be able to have access to the assets that are in the custody of the bankruptcy trustee, but his fresh start is there. No, he can lead his life without having any difficulty about the disqualifications and the restrictions. See, 139 clearly says that the discharge shall release the bankrupt from the bankruptcy debt. So that is completely bankruptcy debt, whatever debt he owed at that day, at that time, is entirely he is released. It is for the bankruptcy trustee to manage the assets, service the creditors. Not only that, he is discharged from all the disqualifications and restrictions also. You can see here, any disqualification shall cease to have effect once he is discharged. So the restrictions, the disqualifications, the debt, liability, everything goes. You can see 139 restrictions. Any restriction which the bankrupt suffers shall cease to have effect when he is discharged. Therefore, the law has given a fresh life to people. It has removed the taboo nature of the bankruptcy. After 1 year, whether bankruptcy trustee has sold all your assets or not, whether all those creditors at that time is settled or not, you are going to be fresh. There is no need for any suicide. There is no need for any worrying. Legally, okay, somebody may say you are a bankrupt and all, that is a different one. But honorably and legally, the person can keep his head high and continue to be living without having any guilt.
Wonderful, sir. Wonderful. Delegates and participants, if you have any questions, the floor is open. And Dr. KSR, a very scarce resources available for you for next 15 minutes. Just shoot out your questions. Yes, sir. Venkatakrishnan, sir, please.
Yeah. Yes, sir. Thanks for a wonderful speech. I'm still wanting to understand. So, if committee of creditors, let's say there's a bankruptcy proceeding, and committee of creditors have initiated the proceedings, what I see under the IBC is that the COC and the secured creditors have a priority over all other creditors, right? So, can me, who's a commercial creditor, who not a financial creditor, initiate an action on the strength of a personal guarantee given by one of the directors or promoters to me for my debt? Is that feasible, which can sustain, irrespective of whether because even the committee of creditors, after the resolution has been done, could also proceed on a personal guarantee basis. So, can I precede them and exercise my right before anybody else?
Under 95, it is perfectly possible.
Okay. And the time limit is not there.
Time limit is, as usual, limitation law will apply.
That's a 3-year from the date. But the cause of action could be that the IBC event. So that could be the cause of action, isn't it? Can I say that 3 years chips in from that time?
It can be, because today the Supreme Court has come in May 2022 for the first time, said whether CARP is there or not, you can proceed. In fact, MS Saab had gone in public domain, and I have an article of that published his statement in Business Standard, that the idea was to commence in phased manner. In fact, Ramakrishnan and Lalit Kumar Jain, para-wise we can discuss, but that will be totally legal interpretation. That is why I cut short all those things. Until this decision of recent decision in Jajodia, the position was clearly understood as no CARP, no liquidation, no proceeding. Today, no CARP, no liquidation, still you can proceed. Therefore, the limitation should be extended to such level that you are able to, provided there is a guarantee. The point is about guarantee. Relationship of guarantor must be established. That will be the starting point.
Not sure, sir. That is well understood. Thank you.
Yes, sir.
Doctor, there's another question, whether the personal guarantor includes the successors or he in case of PG expires.
No, the guarantor's assets may come under question. You cannot treat a person who is probably a legal heir on whom the estate devolves as a guarantor. Not possible. That liability doesn't travel. Liability on the debts, for the debts on the assets, will travel to the estate along with the estate. But the status as a guarantor will not travel.
So the assets are liable.
Assets are liable to the extent that the person has got it devolved on him.
So the successors' individual assets will not get attached.
You cannot, I know, taking forward from what Om Prakash has nicely brought is, you can't initiate these proceedings against a dead person. That's all. That is the point I think he is trying to highlight. I thank you for that.
Yeah. Any other questions you have, delegates?
In fact, hearing is there for me today.
So I think there are no questions. So we will try to close the webinar. Before closing, I would, Venkat sir, can you address the vote of thanks, sir? If I would request you, senior.
You're kind of senior to me.
No, it's one of the subject matter which is engaging all the corporates, I should say, because with the way bad debts have cropped up, and there's always the question which keeps coming up on, there are a plethora of acts, SURFACE Act, where and there are the priority in settlement of claims, which are all mandated. So for corporates like us to think whether we have any possible realization potential for whatever we try to do on the strength of personal guarantees, I think this is an eye opener for us, and I think the what you call the uh, underlying theme which I'm carrying forward after the seminar is that we don't have to wait for a crisis to hit. Even if I have an iota of doubt that is going downhill, I should just exercise the personal guarantee and initiate this step. The voluntary declaration that I am going to be thinking and I try to work on discharge is possibly, given the stigma which exists in India, I am sure it will take a long time for us to evolve on a voluntary basis, but at least corporates can uh, take proactive action. I think that is what I'm picking out of this particular session. And one of the good thing about KSR is that he likes to study the legal part and give the cream or essence to the viewers. I think that is the plus point of KSR, and I'm sure the people who are there online would greatly benefit by this exercise. And thanks KSR for this wonderful session. Thank you.
Thank you, Venkat, and KSR for bringing the essence, and thanks for your wonderful vote of thanks. And I would also thank all the participants who had come here, taken out time, the committee members and the BCCI members and the BCICI secretariat team, Rupa and others, and the co-chairman Joydeep for joining this session. Thank you once again. We will shortly come out with more such
Interactive.
qualitative topics, and we will again look for KSR to come up with yet another topic. And the way he articulated with the Supreme Court judgment and the act and the provisions, really in 45 minutes we really know what is a personal guarantee all about. So whether to give or not give is very important now. Thank you very much, sir. Thank you. Thank you all.
Thanks.
Rupa,
Thank you.
can we do the ceremony?
Not
Yes, sir.
necessarily for our
Yes.
own members, sir.
Yeah, no problem. Thank you, sir. Thank you very much.
Thank you very much,
The
sir.
meeting is adjourned.